This presentation is a general explanation of the California eviction process with some mention of local laws. It was created in September 2024. Please keep in mind that laws and regulations are often updated. While we try to make timely changes and updates to presentations, this may not always happen before your viewing. In addition, this presentation is for educational purposes only. Nothing in this presentation should be considered legal advice. The first step in the eviction process requires a landlord to deliver a termination notice to the tenant. A valid termination notice has three main requirements. It must be written, it must include legally required information, and it must be properly delivered to the tenant. The first requirement, that it be written, means that it must be typed or handwritten on a piece of paper. In other words, a text, email, or verbal statement telling a tenant to vacate is not sufficient for a landlord to start the eviction process. Second, the termination notice must have certain information included on the notice to be valid. This may include statements required by local laws. For example, this might include information about relocation assistance or buyout agreements if the tenant lives in the city of San Diego or the city of Chula Vista. A valid notice also has to have all the statements required under California law, such as statements about abandoned property or statements about how to fix a lease violation, if that's at issue. State or local laws may also require the landlord to give a reason for the termination, often referred to as a just cause reason. Landlords must also notify the tenant of the number of days that the tenant has to move out. A valid notice must also be properly served, which is another way of saying properly delivered. California law provides only 3 ways for the landlord to deliver the notice to the tenant. The landlord may personally hand the notice to the tenant, or the landlord may hand the notice to another adult if the tenant is not present, but the landlord must also mail a copy to the tenant. The last option is for a landlord to post the notice on the door and also mail the notice to the tenant. If the landlord delivers a termination notice to the tenant and the tenant does not vacate, nor does the tenant fix any lease violations, then the landlord must move to the court process in almost all cases before a tenant may be removed. Self-help by landlords is illegal. Self-help is when the landlord removes the tenant belongings, cuts off their utilities, changes the locks, or does anything else to induce the tenant to leave. Step 2 of the eviction process is when the landlord files a summons and complaint with the clerk of the county courthouse. The court will send the tenant a notice of the lawsuit by mail, and the landlord will have a copy of the summons and complaint personally delivered to the tenant. If the tenant receives notice of the lawsuit and the summons and complaint and does nothing, the landlord will likely win the lawsuit without a trial and be able to ask the sheriff to lawfully remove the tenant. A tenant responds to a summons and complaint by filing paperwork in the courthouse known as an answer. Answers must be filed within 5 court business days to protect the tenant's day in court. The answer will contain defenses that the tenant wishes to assert in court. Once that answer is filed, the tenant has now preserved their right to speak about their defenses in court. The landlord may then request a trial. If a trial is requested, the tenant must attend that trial or risk the landlord winning automatically and the tenant having an eviction on their record, as well as a possible money judgment against them. At trial, the tenant and landlord discuss their reasons why they each feel they should be allowed to continue possessing the property. If the judge rules for the tenant will get to stay. If the judge rules for the landlord, the tenant will need to move out of the property within the time agreed upon in court. If the tenant does not move out within that time frame, the landlord will then be able to go to the sheriff and ask the sheriff to lawfully remove the tenant. Let's review some very important information. Landlords must follow the court process to evict. Evictions have very fast deadlines. If you miss the deadline, you may automatically lose your case and be evicted without a trial. If you receive an eviction lawsuit called a summons and complaint unlawful detainer, you only have 5 business days to file your response with the court. The response is called an answer. After filing an answer, the landlord can request a trial that occurs in as quickly as 3 weeks. If you do not appear at your trial, your landlord may automatically win the eviction lawsuit against you. Thank you for viewing our presentation.